my name is, I'm Philip Yu. I got about probably some 30 slides, and I don't think we'll have time to go through every one of them, but I'll go through some key concepts. I know many of you are here for Metaverse, but the thing is, this is really important, like what Marian just said. So I'm going to go over the basic IP. How many people here, let me just start with this. Just a quick one. Do you know what happens if you don't protect your IP? IP meaning patents, copyright, trademark, or trade secrets, or we have additional technology. Does anybody have you guys have any experience in when you lost your IP, or you experienced or getting sued, or somebody's ripped you off?
I mean, I was thinking about him. I was saying like you're using the funds from
that's a
company, so you need to
you gotta pay.
Purchase.
Yeah, you've been
Just never played.
okay. Have you guys got sued? Yeah. Okay. Not yet. No, come to me. No, just kidding. First of all, this is what happens. I typically tell people, do you have any counterfeit problems? A lot of my clients that said, well, I don't have any counterfeit problems. So I say, well, that means your products are probably not that good. So no one's copying your stuff. So just something to keep in mind. Or what happens if you counterfeit products create a health risk? Because if you're not enforcing your brands, you're not protecting your brand, and somebody else gets hurt because of the counterfeit brand, and the consumer is going to blame you. So you have to do something about it. Let's say there is a Colgate or by P&G. If P&G does not take any actions against the counterfeit in the market, at some point then consumers get injured or there's health risk, the government is going to come to go to P&G and say, can you solve the problem? And then P&G is going to be in a very awkward position and say, well, this is not our product. And they're going to say, well, why didn't you do something about it? So this is something you had to do. Also, in terms of IP, when I talk about IP in general, patents, copyright, patents, copyright, trademark, and trade secrets, along with the geographic indicators, and there's also plant variety technology, plant protection. Each country has its own laws. So just because you think you have IP rights back in Malaysia or back in France, back in UK, it doesn't mean you have the rights here in China. You have to you have to make sure you have to do the proper filing in time in order to get the rights registered in China. So this is why we have lawyers in the UK, lawyers in France, working with lawyers in China or lawyers in the US. I myself, first disclaimer, I'm not a licensed Chinese lawyer. I'm a licensed American lawyer, California to be exact. So don't hold that against me. I'm from California. So what I'm talking about is in general IP practices. Make sure you have a local practice, local lawyers to protect your rights locally if you need to worry about them. Like I said, IP is not automatically granted, except copyright. You can do copyright, do it based on the Berne Convention, but then again, in order to enforce your copyright issues, you need it better to have a local registration in China. It's very cheap to do the copyright registration. You can do that here, and it's easier to enforce. Now, the basic thing, I just talked about the four common types of IP: patents, trademarks, design, copyrights, and trade secrets. Patents, it talks about new products, new technology, new process, or this is usually the bread and butter. This is really hardcore technology that goes into hardware, software. We're really making things happen. And I do that a lot because my background is in engineering. So if you're formerly in engineers, physicists, computer science, or mechanical engineers, we can probably talk because you understand what the patent means to you. Usually it's about lasts for 20 years upon the filing. And also you need filing country by country basis. Let's say if you first have a patent filed in Singapore, you usually have 1 year to file it in somewhere else. So if you had missed that deadline, let's say you have a patent filed in Singapore in 2015, and now you want to bring the technology over. So, can I get a patent in China? I said, well, no, it's too late. You just missed your deadline. Usually you want to do that within 1 year. Same as if you have done something in China, and you say, I want to bring the technology, I want to the US. You have to do that in 1 year. 1 year is that's what they call the Paris Convention date. There's 1 year grace period for you to take the technology, to file the patent in China first, and within 364 days, you get it filed somewhere else. Question?
Starting from the application or when you are granted the patent?
No. From the first day when you file, that's the grace. The clock starts.
First day you file, then you can start spreading.
Yeah, because once you get it granted, it's too late. Because not only that, but even before you're granted,
So that's the
filing day, first day when you file. We do the filing date. That's the key. So a lot of people don't realize that. So they have patents elsewhere and say, oh, well, I want to put the technology over here. I'm sorry. Once the patent is published, or once the application is published, which is usually 18 months, it's done deal. I mean, after when you get it granted, that's another few years down the road. So think ahead. That's why you always want to plan ahead and talk to lawyers. Look around if you can have a good lawyers around here. I'm sorry, I'm the only one here, am I? Oh, hey, this is my show, okay? No, we'll talk later. So good, we have lawyers, you want to talk to lawyers, make sure you have local counsel. When you have a patent, does not mean you have a right to practice. Freedom to operate does not have a freedom to operate. When you talk to a lot of Chinese manufacturers, they always say, oh, I have a patent, I have a right to do it. But it turns out this is probably the biggest misconception. 99.9 people are confused about having the patent does not mean you have the FTO. The patent only gives you the right to exclude others. I mean, you're someone else from doing it. It doesn't give you the right to practice. So you need to do, in order for, if you're an ethical company, like my previous employer, for any technology that we roll out to the market, we do a full-scale, pretty much what they call risk assessment, or we call it a freedom to FTO study, in order to understand what are the risks out there. And the FTO involves, let's say I'm rolling out a new technology in China. I probably want to, do a patent search to understand who has patents and what the technology is all about before I roll it out, if I want to be safe. But the thing is, that's why I call it FTO, freedom to operate, is also a risk assessment. Because doing the FTO, let's say, it costs a lot of money, you paid lawyers, you paid the patent searchers, and an analysis takes time away from your technologists, do the review. So this is, it may cost you a few $1,000s just to do a simple FTO on a simple device. So that becomes a sort of risk determination as to, well, can you make that much money? So if a deal is going to worth over $500,000, you can spend maybe $10,000 doing the FTO. If you're only making 50 grand, is that worth the money? So that's why it's a risk, and the risk is something what we lawyers tell our clients, say, hey, this is how much you have to spend. And if you're looking at a big shipment that's going to come to this country, and you're going to have it made, do you want to do FTO? So we always recommend, if your deal is big enough, patent is not going to save you. Having the patent is not going to save you. You got to make sure you have an FTO. Many companies in China, when they are rolling out products, or when they're trying to get IPO listed, they say, we have patents. Well, I say, well, for example, in medical devices, I said, well, have you checked whether your products infringes companies like Medtronic or Johnson & Johnson? They say, well, we don't think we have a problem. Well, who said that? Have you done the search? They say, well, no, we haven't. Well, just look at the product. No, looking at the products in the marketplace, that's not an FTO study. That's that's a product comparison. Patents talk about exactly what Medtronic can do to you. And within the patent, how many people have heard about the claims part of the patent? Each patent has the major parts are specification, which is a description, and the claim section. How many people have heard about the two sections? Claims, description? Okay, good. Do we have another 25 hours to talk about this? Generally, if you look at the patent, a granted patent, the general description portion, we call it specification, which could be 10 or 20 pages to talk about the product, to talk about how to make the product. But when it's a key issue is the claims section, which covers exactly what you have, what your property rights, where your property rights begin and where your property rights end. Sorry, I haven't had enough coffee, so I'm stuttering a little bit. So you want to look at the claims. So claims describe, let's say you have a house on Shanxi-Nanlu, adjoining Huaihai-Lu. This defines your rights and defines your invention. So if you look at This is just a talk, I'm going to the patent claims. Let's say if you are the inventor of the first ever chair, is a chair. Let's say back in the good old days, the Flintstones, they're all standing up, they're getting tired, and they said, well, somebody invented a chair, this chair, and they said, well, I claim this chair with one leg, which is now the first ever chair, one leg. They say, oh, that's the greatest invention. People get to sit down, we can relax. I kind of like this table right here, but it's like a chair. But then later on, you got the second guy who invented the say because a chair with one leg, it's not that stable. You tend to if I lean forward, I fall. So the second guy invented this chair with three legs, because based on geometry, 3 points define a surface. It's more stable. So he also has a patent claim, a sitting platform with 3 supporting legs. Now this guy is going to say, well, no, I have a right to practice. I have an FTO because I have a patent. But the answer is no, because the first guy in front of you has one chair. His claim is a sitting platform with one leg. And here, by adding 2 more legs, this is because 3 legs is 1 plus 2. This guy is still has a FTO problem. He may get sued by this guy, by the first guy. But what is this guy's patent? What can this guy do? Well, he can go after the second guy, the last guy with 4 legs. So this guy can exclude this guy, the 4-legged chair, from the market. At the same time, this person, the guy with 1 leg, can exclude this guy. So this is the poor guy. But this one has the most invention. He can go after the second one and the third one. That's why you always want to make sure. It's great. People will say, well, why did this guy get an invention? Well, he got a patent because he realized that having 3 legs is more stable than 1 leg. So that's probably how he got an invention. That's why this guy didn't foresee that. So there's always a risk. That's what the whole idea of having the patent system is. You disclose something to the public, so people can build on it. And so you have one-legged chair, 3-legged chair, 4-legged chair, and then you have chairs with wheels, and so on. So having the patent means you can exclude other guys from doing it, but doesn't mean you're free from the guy who invented before you. Does the guy have 2 legs? It's a coffee cup example. This slide is always, you can see the slide. Coffee cup, someone invented a cup with the opening at the top. And now, okay. And someone else went down, well, the coffee is going to get hot, we can invent a handle. Great. This is also a patented device. But this guy's device has this, he incorporates this guy's device. So he has a patent, great, but the first cup is still the patent over this guy. So he does not have an FTO, but he can go after the next guy, and so on. All right, I'll jump to the trademark side. I think, any thoughts on patents? I know it confused all of you already. It's a trademark. Trademark is talking about
The FTO required also for the utility model.
Generally, I would say so. You know why? Because FTO requires any time.
Is it a law or not?
Well, yes, because if you want to be absolutely safe, anytime when you roll out a new product, there's risk unless you have done it. How do you know who has patents on what, right? So if you're not selling a product, if you're just applying for patent, we don't care. If you're selling a product, whether you're applying for a patent or not, your product is potentially a risk. Because say, well, somebody can. You should go. Yeah, you should do it. But the thing is, it's a risk assessment. How much do you want to spend on this FTO? And also FTO covers only China or covers China, Japan, Europe, and U.S. The FTO is very, very. A lot of people don't realize that. They say the FTO actually costs money. It takes a lot of analysis. Look at that. It's generally by the law firms, but we get people. If you have technology people that are really very well versed, well knowledge, they can read the patents. They've been trained. They can read the patents. They can determine which one is more relevant. And when you get to really critical issues, say, well, does this particular patent language covers my product? That you may need a legal opinion or legal review. But before that, you can get a lot of heavy lifting done by technologists.
It's a study, or in the end you get a certificate, or
No, FTO, you just get a peace of mind that you don't get sued. You won't get sued when you roll out a product. So, for example, if I'm a business executive, and Stephen here is going to roll out a new toothbrush. Sorry, Stephen. He's going to sell a new toothbrush. I said, Stephen, have you done an FTO? He said, what's an FTO? I said, well, do you know whether the toothbrush is going to infringe Colgate's patents? Oh, I said, I don't know. Well, he's going to conduct an FTO. I look at it and say, well, there are no patents out there, hypothetical. It's good. I said, good. That means give me a little report saying, well, we've done a study, we searched patents, and there are no issues. Or there's a legal leads will say, well, we don't think, it does not seem we have issues. Legal, we never say it exactly. here's a So you get a peace of mind. Now I say, okay, great. I'm going to give you funding to make 10,000 per month. That's just between ourselves.
So it's a market research.
It's a market research of the patent technology, of the patents. If you just look at the market, it's not going to be enough. It has to be based on patents, patent rights, or even for trademark. Sometimes trademark you want to do a clearance search, which is almost the same. Clearance search meaning if you start using someone else, start coming up with a name, like Manners Coffee. I'm sorry, I'm in the wrong place. I mean, if you're coming up with a name called any call, or if you want to set up in my hometown, Pudong. Oh no, sorry, I don't. In my hometown, Los Angeles, you want to set up an MQ Coffee. You better check whether MQ Coffee is a registered trademark in the U.S. If not, then it's free for me to use it. But in China, in Shanghai, they probably have a register. They'll have the name register in the Chinese patent trademark office, so that when they start opening up 10,000 stores throughout China, their market's protected, like Manners, like Starbucks. Without that, once they become successful, if they're successful in Shanghai, you can bet the next guy, the copycat, is going to start in Hangzhou. And by the time, so you want to do your trademark, first of all, clearance to make sure you have the right to use it. And then when you use it, you want to do a trademark registration. And people, when they do trademarks, they get really, really hung up on saying, well, I like the design, I like the design. They'll say, for me, the strongest trademark is the word mark, because people still okay, 3 minutes? Oh, crap, all right. We could talk about that. So trademark is important, especially now in the metaverse world. I'll give you an example later. Brand protection, we talk about that. Design patents, essentially like the shape of the device, shape of the product, and now people are applying that to an interface. Let's say on the iPhone, they have different apps along that. That's Apple actually getting a lot of the design patents for the graphical, the GUI interface. Design, you may hear about the Hague Agreement, which covers you can apply one design patent application to different countries through the Hague Agreement. But right now, China is rolling out the actual implementation rule later this year. But the thing is, it makes it easier. But the problem is, I think the challenge is, once you decide to go through the Hague process, you have to pay for all the countries right at the beginning. So that becomes a huge investment up front, when you may not need all that many countries. Copyright, I talk about copyright. You have books, your novels, movies, and music. And I used this singer like 10 years ago in my slides. It turns out this guy now is what a schmuck. But anyway, that's another story. You have to read the news. Leo. Trade secrets. A lot of things, when it's an improvement over existing technology, you can either apply for a trademark, a patent, or sometimes you prefer to keep it as trade secret. And the key thing is, what is the difference? That's the biggest trade secret versus patent. You want to make sure that if your technology or your product can be reverse engineered by someone else when you release to the market, that's probably something you want to patent, because that's how you can enforce it. But if your product is something that people cannot reverse engineer, people cannot figure out how it's made, that's something you probably keep it as trade secret. And then you rely on your own internal control to keep it out of the sort of spilling out. The biggest trade secret, and those trade secrets can go on forever if you take proper protection means. So probably the best known trade secret is this guy's Coca-Cola's formula. I heard it's locked up in the safe, the formulation, locked up in the safe in Atlanta, Georgia. and no one, and only 2 people will have access to it. And the thing is, that's the trade secret. They will do formulation, they'll mix it up for other people to do the bottling, but they will not release their formulation. Chinese current IP authorities, China IP agency, potential issues in metaverse. I know I have a few minutes. This screen shows that actually I was trying to get involved in it. I started playing with it. I went to Decentraland, and this is me. But you know, I'm a really muscular guy. You know, it's kind of my alter ego. But then I realized I was trying to use a Mac to do it. So I couldn't even I couldn't get through the lobby. So I said, I'll talk to the experts here. Potentially metaverse. We all know what it is. It's something. It's a virtual reality. It's a reality. It's a separate universe. These are the things. If you look at this Matthew Ball, he's got written a good piece about this framework of metaverse. There's a keywords: massively scaled, interoperable network, real-time render 3D, synchronous, persistently, unlimited number of users, presence, continuity of data, and also a lot of things about payments, objects. These are things that define the attributes of metaverse. But I will look at different, potentially, these are the sort of framework of his design. And we can look at potential IP issues. This is a great new technology, but every step of the way, there's opportunity and also risk with it. Hardware. First thing I was talking to Stephen about, the hardware thing is that, all these technology, in terms of getting access, getting to the metaverse, getting this field, I need a lot of invention. VR, the headsets, the mobile devices, because a lot of mobile devices, now one of the things about metaverse is you can access it anywhere from any kind of device. It does not have to be Apple or Huawei. It could be any device. It could be a slower device, but they have to make it available to those guys. And wearable electronics, enterprise hardware. So there are potentially potential hardware designs that allows you to access. These are innovations, but I don't think we can do that ourselves. It takes a team, it takes a company like it takes Apple, it takes Google Glass, and those big guys to do it. Networking. That's also that creates the data communication. That's where I don't think anybody individually can do it. This is for the big chunk of the network providers do it. But these are talking about potential international standards. Brands, because standards is where companies compete. Once they get into standards, you have the standards, then you have the right to dominate. You have the right to name your price. And that's going to be always a fight at the international ITU, International Trade Telecommunication Union, and standards. I also see potentially brands playing a big role. Brands like Trademark, because people will want to work with a more stable. In the good old days when I was growing up, people always say, if any company purchases sourcing, they say, if I buy from IBM, I can never be wrong. Even though IBM may not be the best product or the most sort of a cost-effective, but if I buy IBM, I cannot get fired for buying IBM. So, you have the brand. So dealing with big companies, potential customers, the sourcing people want to look, I'm going to get a brand that offers some kind of stability and credibility. Compute. It takes a lot of computing power to do real-time 3D rendering. That's going to be technology where potential IP, for me, patented technology. But anytime we talk about technology that's going to be released to the public, someone else can always come out a better mousetrap. So I wouldn't depend on sort of patent to protect this particular heavy-duty computing. I would rely on maybe a lot of trade secret. Obviously, a lot of things I want to keep it confidential. Get only a few people, to make sure that your employees, your key employees, are well taken care of. They're not going to take your code and go somewhere else. That's where I see potential problems. Virtual platform. This is the environment you get into. And right now you have Roblox and Minecraft and all these games. And the platform will be accessed through the VR devices or a simple web browser. Like I tried the web browser, it didn't work that well. So I can see a lot of maybe contents, branding, and the underlying enabling technology should be key for us. But the big brand, a lot of people were individual. You don't need a big company to have contents. on branding. But underlying enabling technology, you really need a sort of a critical team. You have to have the sort of the R&D team to support that. Contents and branding, I think I can see that has more opportunities for small and mid-sized or small and micro-sized firms. Interchange tools and standards. This is how things talk to one another. You see, in the metaverse, one can experience it from any local device, anywhere, anytime. That's going to eat up a lot of bandwidth, a lot of computing power. So if you want to, so that's going to be something the major companies going to do because they take a lot of upfront investment. They want to do that. They want to get a return. For the small and mid-sized firm, it may be difficult, but that doesn't mean you can't work on it and potentially get a license or a collaboration with them. One last. This is where a lot of us can have a role: the contents, and the service, and the assets, even in NFTs, because this is where. This is the only thing that probably creates value. People can actually see, actually sell, actually trade. So digital assets, contents, what individuals can do. But I was telling Stephen, when I do an NFT scam in Google, it came out with 34,000 hits on NFT scams. So be very, very careful about this kind of because we don't know, the technology is too new, and also in the metaverse, right now, who are you dealing with? Who's the other side? And where's the government? Which government? What rules govern? Nobody. But that's bad. But at the same time, it's very good for lawyers. Right now, I'm just kidding. That's when you need certainty to out of chaos. But then there's in another way. Well, this is the wild, wild west. This is where opportunities are created. Well, I'm only a few more slides, but I want you to know about NFT and brand because everybody says, "Oh, I can create my own NFT." But then again, Nike purchased a design house to start getting into the NFT business. But I think Nike still wants to sell shoes. They still actually want to make shoes, but they want to get in there to take out the space to prevent other guys from doing that. And then recently, they just sued a reseller, StockX, because StockX, they created the NFT Nike shoes without actually making any shoes. And they started doing their own customization. And Nike said, no, you should not benefit from not spending any dollar on my shoes. So Nike actually sued this guy, and I think they're probably going to win because this constitutes an unauthorized use of trademark, even in the digital sense. So be very, very careful about that. Content is going to be your money tree because you have content, they will require lots and lots of contents in real time. So that's going to be whoever has contents and libraries, maps, or scenery, that's going to be replicated over and develop or evolve. That's going to be key from my perspective. And it's easier for people who already have contents to play a role. If they movie contents and they have maps or street scenes, that's going to be very, very useful. This is my last slide. I just said, I think we're all there. Right? This is not just the end. This is the beginning. And it's going to jumpstart a lot of things. So I will urge you to sort of, I wouldn't want to go in right away. But I would say to sort of observe on the sideline until things are more clear. But even if you do go in, don't bet the whole farm. Just play nice. And also, bring your technology and legal friends with you to join for the joyride. It's going to be a lot of things, a lot of rules to be made. You don't want to be left out. This is my contact information if you need it. These are our firms. It's a small rep office in China, but it's actually 800 lawyers in the U.S., 100 lawyers in Singapore. That's all there is. That's enough of an advertisement. Any questions?